I'm Sarah Howarth. I'm a senior manager here in the tax team at Price Bailey. And one of the particular areas I look after are the off-payroll working rules, commonly known as IR35. So IR35 is actually the name of what was then the Inland Revenue's press release at the time these rules were introduced, and has kind of become a commonly used term to refer to those underlying rules. What those rules essentially seek to do is target arrangements whereby you have a relationship that is essentially one of employment, but where one or both parties, the worker and the recipient, have agreed to put what we would call a personal service company in between them, such that the worker is providing their services as a self-employed consultant to the recipient, ultimately resulting in a reduced liability for both the employer and the worker. So the IR35 rules were really introduced to counteract that back in 2000. There's very little actual written legislation in this area. Rather, we have a set of highly subjective rules which have been built up really since 2000 through a variety of tax cases. Successive governments have agreed these rules just really aren't fit for purpose. But unfortunately, there hasn't actually been any legislative change yet. So really, what we rely on are these very subjective rules, and the cases I'm going to come on to talk about really illustrate how, without proper legislation, you can come to two quite different conclusions based on a very similar fact pattern. I think there's been a succession of fairly high-profile media figures going through the courts in relation to IR35, and the reasons for that are probably quite obvious. These are high-profile people. It kind of sends a bit of a warning shot to everyone else, and obviously these are high earners. The potential tax at stake is quite high. So I'd like to talk about the Lorraine Kelly case and also another IR35 case, which is that of Christa Ackroyd, really just to compare and contrast, as I said, how you can have two very similar fact patterns, but the courts have arrived at two different answers because we don't have very strong underlying legislation. So I'll just kind of walk through both cases, explaining the three main things the courts would have looked at. But before I begin, I think it's just important to say that the courts will obviously look at the underlying contracts, but those contracts must be set aside if they don't actually reflect the commercial reality of the situation, as is often the case in tax. So on the one hand, we have Christa Ackroyd. She was a television journalist for the BBC for many years, a news reporter, if you will, providing her services through a personal service company. Lorraine Kelly, very well known, face of morning TV on ITV, again, providing her services through a personal service company. So as I said, there are three things we look at with IR35. So the first one is the ability to provide a substitute. So clearly, in the case of both Christa and Lorraine, neither the BBC or ITV are really going to accept anyone that isn't Christa or Lorraine. There is a personal performance obligation, so tick. The second one is what's called mutuality of obligation. So for Christa Ackroyd and the BBC, there was clear mutuality of obligation in the contract. It was a 7-year contract with, I believe, 225 days of service required per year. So the BBC are expecting her to provide that number of days of work, and she is expecting to be paid for that number of days of work. So that one was quite clear cut. For Lorraine Kelly, I think it's fair to say there was less in writing. The contract was for a shorter term with no promise of renewal. But I think ask the man on the street and they would, Lorraine Kelly has been on ITV for years. There was a clear expectation that that contract would be renewed. And Lorraine Kelly probably had a clear expectation that ITV would continue to use her. So again, I think that one gets a tick. So what it really came down to, and I suppose I should say at this point that Christa lost her case and Lorraine won, it came down to control, which is the third main test. And this really looks at how much control the client, so BBC or ITV, has over the way you perform your work. So again, in Christa Ackroyd's contract, it was quite specific. The BBC would choose what she reported on and they could veto certain content. For Lorraine, again, less was written down, and she won her case on the basis saying that it was her brand she was bringing to ITV. she chose who she interviewed. If she liked one interviewee more than another, she would skip the second one, overrun. But I think, again, if you ask the man on the street, it's going to be clear that ITV would have been involved in choosing the programme content. Equally, I don't suppose they would have allowed her to do a piece on something that was critical of one of their main sponsors. So I think as a profession, we would kind of view those two cases as being pretty similar, and the distinctions aren't really that clear. But obviously the courts found and came to different conclusions in each case because of these highly subjective tests, which in this case were either passed or failed on the condition of control. But I think what it illustrates is until there is a change in the law, until we have some more statutory tests to replace these very loose subjective tests, there is a high degree of uncertainty. Many people who provide their services through personal service companies have been doing so for several years. I mean, there is quite a lot of exposure if HMRC were to inquire and decide that actually they were employees, deemed employees, and that they should be taxed. I think there's two things here. I mean, the answer will ultimately be what the answer is. It's guided by the facts. What TIS does is it gives people comfort that they can access good advice and that their fees will be covered. Having had experience of various HMRC's investigations, these can go on for years and they are not cheap. HMRC are under an obligation to finish things quickly. They can ask whatever questions they want. They will often ask things that don't particularly seem relevant. And, advisor fees can rack up really quickly. So I'd say that is the main reason for getting TIS. So, it's a cost, but it can save a lot of money and also management time. The alternative might be if you can't afford the advisor fees, you have to handle it yourself. And it can be hugely time consuming and stressful.